Dear viewers, welcome back. This video focuses on the allocation of obligations among the operators within the AI value chain, which I will also call AI supply chain later on, and on their relationships with each other. To illustrate my point, I will use the example of BREST and its high-risk AI system called detection, as introduced by Martin in the fourth video of our series. Under the AI Act, the operators involved in the AI value chain are providers, product manufacturers, authorized representatives, importers, distributors, and deployers. They have been introduced in previous videos in this series, except for authorized representatives and product manufacturers. Authorized representatives are persons located or established in the EU that are mandated by providers established outside the EU to carry out their obligations on their behalf. Product manufacturers are manufacturers of products covered by EU sectoral legislation listed in Annex 1 of the AI Act. For example, the Medical Devices Regulation. They are subject to obligations if they qualified as providers of high-risk AI systems. This is the case if their product is itself a high-risk AI system, or if it integrates a safety component qualifying as such, and which is either placed on the market together with their product, or put into service under their trademark after the product's placing on the market. As the AI Act imposes obligations on all the operators in the value chain, when it comes to high-risk AI systems, I will solely focus on these in this video. Providers are primarily responsible for demonstrating compliance with all applicable requirements. For example, the drawing up of technical documentation and instructions for use, as well as the implementation of a risk management system. Though, in many cases, providers work with third parties that supply AI systems or parts thereof, for example, pieces of software or other components that are integrated or needed to develop systems. Therefore, such parties and providers are required to enter into written agreements that include the necessary information for providers to achieve compliance. What's also important to note about the provider qualification is that sometimes other actors, namely distributors, importers, deployers, or even third parties, may end up qualifying as providers of high-risk AI systems. It will be the case if any such actor puts its name or trademark on a high-risk AI system, unless a contract provides for another allocation of obligations. If they make a substantial modification to a high-risk AI system, for example, by changing its intended purpose, in such a way that it remains high-risk after the modification, or if they modify the intended purpose of a non-high-risk AI system, which consequently becomes high-risk. In those situations, the AI Act requires the initial provider to cooperate with the new provider and to provide it with the necessary information and assistance. Yet, if the initial provider clearly specifies that its AI system may not be changed into a high-risk system, this obligation is not applicable. If the provider is established outside the EU, it must appoint an authorized representative and work with an importer. This would be the case for BREST, which, in our example, is established in the US. BREST could have a subsidiary, for instance, in Ireland, and appoint it as authorized representative. To place detection on the EU market, BREST could also work with additional external partners. Detection might, for instance, be imported in the EU by MedDev and then distributed by Extended. As they would respectively act as an importer and as a distributor, these two companies would be subject to specific obligations. For instance, MedDev and Extended would both be required to verify that detection bears a CE marking and is accompanied by an EU declaration of conformity, and to cooperate with the competent authorities, for instance, in the case of an investigation next to a malfunction. Besides, neither of them is allowed to place detection on the market if they have reasons to consider that detection is not in conformity with the regulation. In this type of situation, close cooperation is required to allow the provider to bring the system into conformity as quickly as possible. To enable such cooperation, a sound measure could consist in defining a specific procedure beforehand, for example, in the import or distribution contracts. After placing detection on the market, MedDev and Extended must also report to BREST, for instance, in case of risk to the health, safety, or fundamental rights. This reporting obligation further applies to Extended towards MedDev. Here again, it would be safe and sound to define the specific procedures in the contract between both parties, setting out how to deal with this type of situation. On top of these common requirements, MedDev and Extended respectively face additional layers of obligations. For example, before placing detection on the market, MedDev must verify that the conformity of the system has been assessed, whereas Extended must verify that detection is accompanied by instructions for use. Furthermore, if Extended believes that detection is not in conformity after its marketing, it has to withdraw, recall, or take corrective actions vis-à-vis detection, or ensure that providers or importers do so. Once again, to deal with this type of situation, contracts should define the procedure to be followed, in particular to determine how to inform the other parties, within which time frame, and what actions should be taken, in which order and how. When AI systems have been placed on the market or put into service, they may be used, as the case may be, by their provider, which would therefore also qualify as deployer, or by deployers and/or persons who are not acting in a professional capacity. For instance, applicants who use a chatbot deployed by a company, the deployer, to evaluate candidates for an open position. Only deployers, so professionals, qualify as operators, meaning that non-professional users are not subject to requirements. Let's take a look at deployers' obligation. First of all, some deployers are compelled to perform a fundamental rights impact assessment before deploying certain high-risk AI systems. The logic is similar to that of the GDPR for Data Protection Impact Assessments, or DPIAs. In short, it consists of an assessment of the risks of harm that might be caused to natural persons. This obligation applies to public bodies and private entities providing public services that deploy systems listed in Annex 3, except those relating to critical infrastructure. In addition, it applies to all deployers of systems used for credit scoring or life and health insurance. Second, after the making available of the system on the EU market, or its putting into service, other obligations are applicable. Taking back the example of detection and assuming that it's used by a hospital in Belgium, as a deployer, the hospital is, for example, required to ensure that detection is used in accordance with the instructions for use and to assign human oversight to people having the necessary competence, training, authority, and support. The hospital must also ensure that the input data, here medical imaging, is relevant and representative, store the system's logs, and monitor its operation. In addition, if the use of detection according to the instructions for use might present a risk, the hospital must inform BREST or Extended and the Market Surveillance Authority. In such a case, the use of detection must also be suspended. The hospital is required to report serious incidents as well. Once again, it appears appropriate to organize contractually the implementation of these reporting obligations. That's it for the AI value chain. Thanks for watching and stay tuned!